Welcome to the Law in Context podcast.
I'm Emeritus Professor Stephen Bottomley, former Dean of Law at the Australian National University in Canberra.
And I'm Emeritus Professor Stephen Parker, former Dean of Law at Monash University in Melbourne.
Between us, we have written books and articles on corporations law, lawyers' ethics, family law and many other legal topics.
In most episodes, we take a legal topic of interest, perhaps one that's in the news, and relate it back to fundamental questions about the legal system.
So whether you are a member of the public wanting to know more about law and make sense of what is in the news, or you are studying legal studies, criminology, or even a law degree, our plan is to help you with a deeper understanding of what is going on.
Any competent lawyer should be able to tell you what is the law on a topic if it's in their area of expertise. But most lawyers struggle to answer the general question, what is law? It's an important question because law pervades our lives. The English legal theorist William Twining used to ask his first-year law students to open a newspaper and highlight stories that related to the law. Today, with online and social media, the result would be the same as then. Students would have difficulty deciding what to leave out. The law mandates, facilitates, prohibits, protects, regulates, or sanctions all aspects of our lives. So asking what makes law law-like is one way we can understand how our society ticks.
If there is anyone out there who has listened to every episode, they will know we have chipped away at the question, what is law? We've discussed the rule of law, we've looked at where law comes from, and we've asked why people obey it. We've also had 2 episodes with justice in the title. Surely these must be relevant to this topic as well.
Yes, maybe. Like many complex issues, it's helpful to make some basic distinctions. Here we start with the difference between what philosophers call positivism and natural law.
Positivism comes from the verb to posit, or to lay down. So a positivist says that law is whatever comes out of the correct procedure for making law, and the correct procedure is found in a country's constitution. You may not like a particular law, you may think it is unjust or immoral, but nevertheless, assuming it has been made constitutionally, it is a law until changed. And the sum total of laws is the law with a capital L.
This is attractive to many people. It keeps things in their place. It also keeps law separate from questions of morality. Yes, you may critique laws from a moral perspective, but the law is not intrinsically moral or immoral. You may pass laws because of your moral beliefs, but they're still separate things. You may argue that some laws should not or need not be obeyed because of your morality, but you don't have to doubt their validity as laws.
However, many positivists wilt under a little pressure. Suppose a democratically elected parliament starts making retrospective laws and violates what we think of as primary requirements of the rule of law. If you start to say that a new act of parliament isn't law because it violates rule of law principles, you are letting a political philosophy in. You are saying that ideas such as fairness or equality are necessary parts of law.
But it's the alternative tradition of natural law theory which takes the challenge to positivism head on. In large part, natural law has religious origins, particularly in the form of natural rights. A key figure in the history of the idea, St. Augustine, in about the year 400, is said to have announced that unjust law is not law, which sums up that position. It is only law if it passes some non-law test, such as religion or morality. This contrasts with the English philosopher Jeremy Bentham, a strident positivist who argued in 1796 that natural rights were just nonsense upon stilts.
These days, a belief in fundamental human rights might have the same function, to the extent that some say a positive law which violates them does not have the force of law, which is a natural law position. You don't have to be religious to see some merit in natural law theory, What the Nazis did in the 1930s and 1940s were not at the time all crimes under international law, but prosecutions after the Second World War relied on the existence of crimes against humanity that had simply not then been recognised before in positive law. If it was a crime, even though there was no positive law, it must have come from some natural law.
As if things aren't complicated enough, you could say there is a third tradition, which we would call a critical one. Suppose language is always vague to some extent. Suppose there are usually different ways of manipulating language to get to different outcomes. In other words, if law is indeterminate, as the expression goes, then the judge must be drawing on something else to make their decision. You might say it is their politics, or it is their morality, but it isn't law, because in this tradition, law can't supply all its own answers. In the first half of the 20th century, some legal scholars called themselves legal realists and took this position. By the end of the 20th century, influenced by feminist and critical race theories, a more strident version of it emerged as critical legal studies. A more benign version is in the work of Ronald Dworkin, who pointed out that law is more than just rules. It also contains principles which guide an answer but don't determine it. A judge has to interpret and apply these principles, and in this way, morality becomes a part of law and not just an external perspective.
And at some stage in this series, we'll have to talk about law and economics.
If we must.
One version of this claims that law is really just efficiency in action. It might look like law because of its language, but what is really going on is a search for the most efficient outcome in typical fact situations.
Perhaps there is no universal definition out there, no single essence of law. Perhaps people understand law differently depending on their circumstances and their experience with the legal system.
And the question becomes even more complicated when different systems of law come together. For example, when we think about the laws of First Nations people. We'll look at First Nations legal issues in future episodes.
And does it matter if we cannot reach a universal answer to our question, what is law? Perhaps the real point is the importance of asking the question. An interest in jurisprudential questions like this deepens our understanding of law. And you never know when you'll be drawing on that understanding. You may not even realise it when you do.
Oh, great. Another school of thought, the invisible theory of law.
Thank you for listening to this episode. You can find more episodes in this gripping series at lawincontext.com.au or wherever you get your podcast.
Over time, we will build up resources on the website with further exciting reading on the topics we've discussed.
We're the two Steves, and that was a Law in Context podcast.
And as the two Ronnies used to say,
it's goodbye from me.
And it's goodbye from him.
Bye.
So, are you a positivist?
Nope, I'm a realist.
Isn't that unnatural?
No, you're thinking of economics.